Aloha! Welcome to the Freedom Government. My name is Cale McCollough, founder of the Freedom Government, and we are going to learn about disparate impact claims and federal disability discrimination law from the New York University Proceedings. This is an interesting organization. They are online journal of NYU Law's Moot Court Board, documenting new approaches to unsettled legal questions proceeding from moot court activities, particularly law student competitions. This article is by Elizabeth Schwartz. Together, the Americans with Disabilities Act and Section 504 of the Rehabilitation Act provide federal protections for individuals with disabilities in a wide variety of contexts. However, while parties can pursue a private right of action under these statutes, circuit courts are split on whether to recognize disparate impact discrimination claims. This contribution argues that Supreme Court precedents and statutory purpose require that disparate impact claims be cognizable. Litigants may bring claims alleging disability discrimination under the Americans with Disabilities Act of 1990, hereinafter the ADA, which addresses disability discrimination by state and local governments or in places of public accommodation, and Section 504 of the Rehabilitation Act of 1974, open paren, quote, Section 504, end quote, end paren. This is why I like it when you say hereinafter, because, I mean, both of them work here in this context, but if I said hereinafter Section 504, this is just going to make it read quite a bit better. Which addresses disability discrimination by federal grantees. Regarded as the, quote, twin pillars of federal disability discrimination law, end quote, these statutes provide individuals with disabilities a range of protections, including in the areas of education, employment, transportation, public accommodations, and access to state and local government services, such as universities and the tuition overcharges for qualified disabled students who were unable to pass their classes due to their disability and then being priced out of graduation by running out of financial aid and becoming in debt without the degree to pay it back. To succeed on a claim, a plaintiff must allege one of the possible theories of disability discrimination, disparate treatment, open paren, also referred to as disparate intent, end quote, disparate impact, or failure to make reasonable accommodations. Claims of disparate treatment or failure to make reasonable accommodations are well established in case law, but disparate impact claims remain an unsettled area of law. And in fact, in my particular case, McCollough versus Portland State University, they actually use this. It's not well established case law. It's well established common law. I mean, case law is kind of, a substitute, but you could also say that civil law also is case law. So I don't think that is best wording. It should say common law, because that's what the United States Constitution specifically says that it recognizes. It does not say that it recognizes civil law. This is a very clear distinction as to why this grad student used the wrong word here. Specifically, circuit courts remain divided about whether disparate impact claims are cognizable under Title II of the ADA or Section 504. This contribution argues that disparate impact claims must be cognizable under either statute to be consistent with Supreme Court precedent and statutory purpose and scheme of both statutes. In Doe versus Blue Cross Blue Shield of Tennessee Incorporated, the Sixth Circuit considered a claim of disparate impact discrimination based on Blue Cross Blue Shield's requirement that the plaintiff receive his HIV medication by mail rather than through a local pharmacy. The plaintiff alleged that this policy had a greater impact on him and other individuals with HIV than it would for individuals without a disability. The court found that the defendant for the defendant and held in part that disparate impact claims are not cognizable under Section 504. However, the Sixth Circuit premised its decision on a mischaracterization of the Supreme Court's opinion in Alexander versus Choate. I apologize if I mispronounce Choate. If two vowels go walking, the first one says its name. So it's C-H-O, Choate, or it might be Chout. I apologize. I'm going to say Choate because of my understanding of English. By asserting that it was an open question of law whether disparate impact claims on the whole can be cognizable, and that the court was, quote, now resolving what Choate did not, end quote. A close reading of Choate reveals that this misrepresentation to be inaccurate. In Choate, the plaintiff alleged that a change in the Tennessee Medicaid program would affect individuals with disabilities more significantly than the rest of the population, constituting a violation of Section 504 under the disparate impact theory of discrimination. Writing for the majority, Justice Marshall's opinion navigated a middle course, open quote, while we reject the boundless motion that all disparate impact showings constitute prima facie cases under Section 504, we assume that deciding that Section 504 reaches at least some conduct that has an unjustifiable disparate impact on the handicapped, end quote. Every disparate impact claim might not be cognizable under Section 504, but some must be, least, quote, one of the government's goals so overshadows the other as to eclipse it, end quote. While the plaintiff's particular harm was found not to be cognizable in Choate, the court upheld the analytical framework first put forth in Southern Community College versus Davis. That Section 504 guarantees that individuals with disabilities be provided meaningful access to government benefits, and reasonable accommodations might be required to ensure this access. Thus, the question left after Choate is not whether Section 504 and the later enacted ADA prohibit disparate impact discrimination, but where the outer boundaries of such claim should be drawn. Blue Cross Blue Shield ignores the nuances of Choate's holdings and accordingly reaches the wrong result. In contrast, the Third and Ninth Circuits have upheld the right of individuals with disabilities to bring disparate impact and discrimination claims, relying upon the holdings in Choate. In Payan versus Los Angeles Community College District, the plaintiff alleged that a public community college's policies had disparate impact on individuals with disabilities. The Ninth Circuit affirmed a private right of action for disparate impact claims, citing to Choate and other Ninth Circuit precedent that demonstrate the historical understanding that Section 504 and the ADA were specifically intended to address both intentional discrimination and discrimination caused by, quote, thoughtfulness, indifference, end quote, which is exactly the crux behind my case, McCollough versus Portland State University, is that, the universities know if you just charge people full price to retake a class, who are the people that you are charging? You're charging like the children of the poor kids, the ones who are not very smart, the ones who are mentally disabled and handicapped, such as myself. And the overcharges can become enough such that the student cannot be able to graduate. The student has not been kicked out of the college at this point in time. And I argue that at that point in time, the college can no longer charge the disabled student to take the classes required for his degree, or his, her, or he, or them, or whatever pronoun you want to use for your degree, because you already paid for it. If the school failed to get you through in a reasonable amount of time, this is actually the school's fault, not the qualified disabled student's fault. There was some sort of deficiency. We needed to cure it. This isn't a money-making venture here. We're here to help people. That's the mission of the school, and that's what they need to do. And the administration needs to take a pay cut so that the disabled students can graduate. Sorry. Likewise, in Doe 1 versus Perkiomen Valley School District, the Third Circuit considered a case in which a class of students with disabilities filed a disparate impact claim after their school district rescinded a universal indoor masking policy during the COVID-19 pandemic. The plaintiffs alleged that retracting the mask mandate would exclude children with disabilities from their public schools. In response, the defiants argued for the court to embrace the Sixth Circuit's approach to Doe versus Blue Cross Blue Shield of Tennessee, Inc., and hold that Section 504 in the Americans with Disabilities Act do not prohibit disparate impact discrimination. The Third Circuit rejected the defendant's argument, noting that following the Sixth Circuit would be inconsistent with Supreme Court and Third Circuit precedent, end quote. Insisted that the court applied the framework presented in Choate to evaluate a facially neutral policy that looked to whether the policy denied meaningful access and whether reasonable accommodations could be made. Be pretty reasonable if they made the online classes cheaper, you know. Allowing disparate impact claims under the ADA and Section 504 is consistent with the legislative intent and the broader statutory scheme of the statutes. As noted in Choate, the legislators who enacted Section 504 considered disability discrimination to typically be the effect of negligent or thoughtlessness, rather than intentional wrongdoing. Representative Vanek, who introduced an earlier version of the act in the House, positioned his bill as solving one of the country's, quote, shameful oversights, end quote, and described individuals with disabilities as, quote, as often, quote, shunted aside, hidden, and ignored, end quote. That's how I feel. Senator Williams, the chairman of the Labor and Public Welfare Committee that reported out Section 504, stated that the, quote, the neglect of the handicapped is a stain on our collective consciousness, end quote. The problem that the act sought to solve was framed as one of the unintentional neglect rather than purposeful malice, and the legislative intent of the bill extended to the kind of discrimination that results from facially neutral policy with disparate effects. Further, an explicit purpose of Section 504 was to prohibit the architectural barriers, a specific form of unintended disability discrimination concerning the building design in order to increase access to individuals with disabilities. The Senate Committee on Labor and Public Welfare specifically noted that the, quote, enormous physical barriers to the mobility of the handicapped individual, end quote. If intentional discrimination was all that the act addressed, it would have no effect on this central issue because these barriers at issue were clearly not erected with the purpose of excluding or discriminating. Building must be made accessible to individuals with disabilities, even when the architecture does not intend to exclude them. Thus, it is consistent with the overarching statutory scheme to broadly prohibit unintentional disparate impact discrimination, such as the case with McCollough versus Portland State University. In Show 8, the Supreme Court reasoned that disparate impact claims were essential to realizing the stated goal of federal disability statutes. Although the court did not issue a broad statement recognizing all disparate impact claims, it applied a balancing test to determine whether the meaningful access had been provided and whether there existed a reasonable accommodation that should have been made. The Sixth Circuit should have denied the Blue Cross Blue Shield plaintiff claim within this framework, but instead chose to decide the case outside the boundaries of Supreme Court precedents and with well-established legislative intent. Courts that have not yet considered this question should follow the approaches adopted by the Ninth and Third Circuits, in accordance with the Supreme Court and the core purpose of the legislation, and hold that disparate impact claims are cognizable under the ADA and Section 504. And is that the end of it? Here we get the citations. Elizabeth Schwartz is a JD candidate 2023 at New York University School of Law. This contribution does not necessarily represent the views of the author. That's kind of a weird thing to say right there, right? I wonder if there's anything else interesting here. No, I don't think you're entitled to a due process claim on the ADA, right? Okay, so for anything that's in the Constitution is a guaranteed due process claim. Then they're going to have the substantial evidence burden. Or at least that's the way that it's supposed to be. Apparently it's not. Case law due to qualified immunity. So, hey, thank you for tuning in. Please stick around for the live stream. But for the pre-recorded viewers, again, my name's Cale, founder of the Freedom Government. And don't forget to smash that like and subscribe button and ring the bell for notifications. You'll be seeing a lot more good content from the Freedom Government coming up here pretty soon with our freedom voting machines. and our open source government initiative. Thanks for watching. Aloha. Farewell. Sayonara. Peace be with you. Godspeed in your journeys.